Welcome you to our Teaching Justice webinar series. Today, we are so excited about our session, which is entitled Teaching Abolition Feminism Through Work with Criminalized Survivors, led by the amazing Leigh Goodmark from University of Maryland, Carey School of Law. Welcome, Leigh.
And
I'm Leigh so much for having me.
Yeah, we're so happy to have you. I'm Leigh. I'm a clinical professor of law at Tulane Law School. I'm also with Allison, co-chairs of the Best Practices in Pedagogy Committee, the Teaching Justice webinar, which is part of the Best Practices in Pedagogy Committee of CLEA. And this webinar series is a project of CLEA's Best Practices Committee. We've featured a bunch of just truly amazing colleagues and innovative clinical faculty who are discussing kind of new approaches to teaching justice in the classroom and thinking about how to be informed by current social justice movements and really examining it from a number of different perspectives, lenses, from economic justice, racial justice, criminal justice, and then of course thinking about all the kind of intersections that exist. So we are so excited for today's session. We also want to let you know we have a full lineup in the spring, and so encourage you to kind of stay tuned. After this session, we'll kind of be sharing kind of the spring lineup and registration and kind of all of that, and you can always find out more information on the CLEA website.
And you have already gotten an indication that this session is being recorded, and it will be made available to you on our CLEA website, which is also home to all of our past sessions over the last few years. We will circulate that information after the session concludes. And for this session, we do encourage you to use the chat function for a comment or a question. We'll be monitoring. We're going to make time at certain points, I believe at the end, for Q&A. And we ask for everyone to, during the pendency of the presentation, to please mute yourselves, but we welcome you to leave your videos on if you are comfortable. So with that, again, we are going to turn it over to our amazing presenter, Leigh Goodmark, today. Take it away, Leigh. Thanks again so much for joining us today.
Thank you both. And thank you for having me. It's an absolute pleasure to be here as a former CLEA board member, CLEA vice president, CLEA president, and CLEA past president. I have been involved with CLEA for a really long time, and it's super, super exciting to see us doing this kind of work together. I absolutely love it, and I'm just thrilled to be here. I am going to be talking today about my work, and so I'm going to share the screen, and hopefully that's going to go successfully. Let's see. Okay. All right. So, but of course I've shared it. Oh, well, it doesn't matter. I have the wrong screen shared, and so I'm looking the wrong way. So you'll forgive me in my little tiny box if I look weird. All right. So I'm going to talk today about teaching abolition feminism. And, I just want to start by acknowledging that, oh, shoot. Hang on a second, you guys. I'm glad I'm with people who love me because they won't mind that I forgot to do the full screen share. Hang on. So this is actually a really nice segue into my talk because it reminds me that I'm old and don't use technology well, which is part of the point of this talk. Okay. There we go. What are you seeing? You're seeing the wrong screen, right?
Yeah, we can see the preview next slide.
God, I hate my life. Hang on a second. Okay. I think I got it now.
Yeah,
do I have it now?
You've got it.
Thank you so much. Okay, so that is actually where I wanted to start, which is with this picture of me at 26 years old. And I'm starting from that place because the way that I began this work was as a 25, 26-year-old young lawyer who came straight through college into law school, came out of law school in 1994, which for those of you who do anti-violence work know is a pretty significant year in the anti-violence world, because it's the year of the passage of the Violence Against Women Act. When I came out of law school, there was a pretty standard received wisdom about intimate partner violence. And it went like this. Intimate partner violence, and at that time, we didn't even use that term, we used the term domestic violence, is about one person's desire for power and control over their partner, sometimes in the service of the patriarchy. And the only way to deal with this problem was to lock people up. That criminalization was an unalloyed good, that it did really important work in terms of decreasing and deterring intimate partner violence. And that we should be, as feminists, because that was the orientation that I came to this from, deploying the power of the state in order to ensure that women were being, and again, at that time we were only talking about women, that women were being protected from abusive men. And it was very much kind of that binary and that blunt, and that was our focus. And that was me. I was a carceral feminist, and I don't use that term in a derogatory manner, although I know that many people kind of understand it to be a derogatory term. I use it as explanatory. I came to this work as someone who deeply believed that the power of the carceral state was what we needed to ensure that intimate partner violence would no longer happen. And so that was very much my orientation going into this work. It was my orientation at the time that I started representing clients. And of course, as soon as I met my first client who said, I don't want my partner locked up, that's not going to help me. That's not going to help my family. That's going to mean ostracism from my community. It's going to mean that I don't have access to resources that I need, that I don't have childcare, that I don't have a roof over my head, and all of the things that clients have been telling anti-violence professionals, lawyers, advocates, and others for years. I started to rethink whether the intervention of the carceral state really was the good that I had believed that it was. And very, very slowly, I began to evolve. And the more conversation that I had with clients in the years that I was a legal services lawyer, the more that I came to question the value of intervention by the criminal legal system. Now, understand that's different than saying, I think it's doing harm. So at that time, it was just, I think it might not be doing what we think it's doing. And so I joined academia. My very first law review articles are, I'm not sure the legal system is doing what we think the legal system is doing. And I'm teaching students and saying, check this out, but I'm not sure we're doing the good that we say that we're doing. In 2012, I wrote my first book, A Troubled Marriage, which essentially makes the argument that the legal system is not doing the work that we think it's doing, but it can be fixed. By 2018, I had written a book called Decriminalizing Domestic Violence, which said, well, the legal system is not, in fact, doing any of the work that we think it's doing. It's not decreasing intimate partner violence. It's not deterring intimate partner violence. In fact, it's exacerbating some of the correlates of intimate partner violence, and I'll talk about that more in a second. But I'm not ready to throw it out yet. I can't see it. I don't get it. I'm not there. And so it was not an abolitionist book. By 2020 and the murder of George Floyd, I think like many people, I was ready to say, this system doesn't work and it's not fixable. And so that was around the same time that I started writing my latest book, which is called Imperfect Victims, Criminalized Survivors and the Promise of Abolition Feminism. And the book owes tremendous debts to people who had been doing this work for quite some time, and specifically within the context of the anti-violence community. So looking back, for example, at Angela Davis's work, and particularly in Women, Race, and Class, where she's raising these issues, at Beth Ritchie's early work, Compelled to Crime, as early as 1994, Beth Ritchie is saying, there's all kinds of stuff happening in this system that you don't think is happening. Looking at the work of Andrea Ritchie on police violence in the context of intimate partner violence, really drawing on the work of women of color feminists, and particularly Black feminists, who came from the anti-violence community and were saying, this system is not fixable. It's not doing the work that we think it's meant to do, and it's not fixable. So I came to believe sufficiently that I could put it on the cover of a book, that abolition was actually the way to go, and that there was a particular strain of the abolition literature around abolition feminism that really resonated with me. And so that's a little bit what I want to do today. I want to kind of talk a little bit about the book and what's in the book, and then talk about kind of what we do in my clinic and how we teach this and why I think it matters. So as I said to you, for the last 40 years, the criminal legal system has been the primary societal response to gender-based violence in the United States. Criminalization was meant to increase our understanding of gender-based violence and to decrease the level of that violence by changing community norms around its acceptability. But one of the serious consequences, and perhaps the most serious consequence of those efforts, has been the increased rates of arrest, prosecution, conviction, and incarceration of the people who it was supposed to protect, and that's victims of violence. In fact, so many victims of violence have been caught up in the criminal legal system in recent years that a whole hashtag, an entire movement known by the hashtag Survived and Punished, has emerged to protest their re-victimization by the criminal legal system. And note that I don't call this an unintended consequence. Women of color, particularly, as I said, Black women in the United States, had warned us for years that increasing the reach of the legal system would harm women of color. And we have seen that result for too long now to argue that those consequences are unforeseen. So my book talks about the idea of imperfect victims. So the criminal legal system protects perfect victims, blameless victims who are usually meek and weak and passive, but also white and straight and cis and able-bodied, and you can keep going. We're pitted against monstrous perpetrators who are usually seen as men. But victims of violence don't always, or even often, conform to these stereotypes. Sometimes they're angry, sometimes they fight back, they do sex work, they have mental health issues, they use substances, and I could go on and on and on. These are imperfect victims, and these imperfect victims face very harsh treatment from the legal system. So survivors generally come into the legal system in 3 different ways. They come in as victims, and I'll just give you a quick example of each of these ways that comes from the book. In 2017, a woman named Cassandra Jackson sought a civil order protecting her from her partner's abuse. When that order was denied, she slapped a sign on the wall. The magistrate ordered her incarcerated for 5 days for contempt of court as a result of her belligerence. In 2018, Ms. Jackson came back to the same court to seek another order. When she was told it was too late in the day, she began pleading with a man in the hallway. The same magistrate left his courtroom, chased her down the hall, grabbed her, and directed Ms. Jackson back to the courtroom, where he found her in contempt again, and this time sentenced her to 10 days of imprisonment, again, because she had been belligerent. The other place, people come in as witnesses, and they often come in as a result of the use of material witness warrants. That's kind of a whole separate conversation that I am always happy to have. And in that context, just to kind of give you the background on that, prosecutors often, when they feel that they cannot make their case without the participation and testimony of the victim, will use material witness warrants to have victims of violence held if they're not willing to comply with subpoenas. And so people are actually arrested and held for various periods of time, and that period of time can be as long as 6 months or a year until they give their testimony. Over a dozen victims of intimate partner violence in Washington County, Tennessee, were jailed after they declined to participate in prosecution. And the prosecutor, Tony Clark, defended that policy, saying that prosecutors needed to send a message. Clark said, "I'm not going to go back and apologize for what we've done, because I think we were doing the right thing. At some point in time, where do we draw the line in saying that we're just going to dismiss these cases if a victim doesn't appear?" Donna Oliver was one of the victims who was jailed after she failed to appear. She described how she was grabbed by both male and female guards, thrown down, sprayed, had every ounce of clothing taken from me, even my glasses. My knees were badly bruised. You could see grab marks all over my legs. Correctional officers said they had, in fact, used force and chemical spray against Oliver. And notwithstanding these claims, the prosecutor denied that the use of arrest was harmful, saying, do I think we're re-victimizing victims? No, I don't. And then, of course, people come into the system as criminal defendants, and they come in as criminal defendants in a variety of ways. The kind of classic portrayal of this is the victim of intimate partner violence who has used force in self-defense against a partner, but people use force for other reasons as well. They use force when they're frustrated. They use force when they're angry. They use force when they're trying to protect someone else. People commit crimes at the direction of and out of the fear of their partners. So people may be engaging in prostitution because they are being pimped out by their partner. People may commit robberies or other kinds of what's so-called violent crimes against third parties because they've been ordered to do so by their partners. A survey of incarcerated women in Oklahoma found that over 80% of women whose husbands were involved in their crimes and more than 75% of those whose boyfriends were involved in their crimes had been abused by their partners previously. And then, of course, victims of violence are held accountable for the crimes that are committed by others. So that may play out as felony murder. That can also play out as failing to protect a child against a partner's violence. Just to give you a sense of what abolition feminism is, Alison Phipps defines abolition feminism as a feminism that opposes rather than legitimates oppressive state systems. The criminal legal system routinely punishes victims of violence. And so there are all kinds of ways in which victims of violence are being punished. And for some people, and so just to give you a sense, I'm going to double back for a second, just to give you a sense of what that looks like, right? It begins when people are children, girls are brought into the system on a regular basis. It continues when people are victims and witnesses. It's at its apex when people are criminal defendants. People are detained, arrested, prosecuted, sentenced, and incarcerated. Our clients are placed on sex offender registries. Our clients who've been convicted of crimes related to their own trafficking are placed on sex offender registries. They live under draconian conditions of parole. Criminalization was supposed to benefit victims of intimate partner violence, to keep them safe and to ensure that those who harmed them were held accountable. Instead, that system is doing huge amounts of damage to the people it was meant to protect. Now, for some people, the answer to this problem is reform. You fix the parts of the system that are harming victims of violence while you basically leave the apparatus of state punishment intact. And I'll say, in my first two books, that's what I thought. We could fix it. Much more convinced of it in the 2012 book than the 2018 book. But even in the 2018 book, I talk about, for example, the fact that people who experience intimate partner violence or other forms of trauma are also re-traumatized while they're incarcerated, and suggest, well, PREA, the Prison Rape Elimination Act, is going to take care of that. Well, anybody who's worked with an incarcerated population knows that PREA is pretty limited in what it actually does, and that many of our clients are afraid to try to access remedies pursuant to PREA because of the way that they're retaliated against inside of carceral systems when they do so. So some people believe that we can fix these things. I've come to believe that we can't, that reforms cannot and will not prevent the punishment of survivors of gender-based violence. And here's why. Reforms largely center on fixing the carceral system using things like diversion programs, or adding defenses, or amending sentencing laws, or improving the conditions of confinement. They use terms like gender responsive and trauma informed. Now, all these reforms may be well-intentioned, and some of them do speak to very real problems in the criminal legal system. But because they largely accept the intervention of that system as a given, they have the potential to do serious harm and to preempt the kind of change needed to prevent survivors from being criminalized in the first instance. Almost all of these reforms rely on actors within the system to use their discretion appropriately, but we know that these actors misuse their discretion all the time. Discretion is what allows police and prosecutors and courts and chief executives to rely on victim stereotypes to dismiss the victimization claims of criminalized survivors. Discretion is what allows law enforcement to blame victims who fail to turn to the criminal legal system for assistance. Discretion creates space for judgments that the failure to leave or to call police or to assist with prosecution means that a victim's story of violence is not credible. Discretion is masking implicit bias and outright racism in how police, prosecutors, and executives are exercising that power. And of course, most reforms don't focus at all on the structural conditions that bring survivors into the system in the first instance, things like poverty and racism. Leaving the basic structure of the criminal legal system intact legitimates that system and preempts more radical change. Abolition feminism is, I have come to believe, the only politics and practice that is going to prevent the punishment of survivors. And it's worth noting that several prominent abolitionists, including Miriam Kaba and Beth Ritchie, came to abolition through the anti-violence movement. They saw the damage that had been done by an anti-violence movement that was colluding with the state to build repressive systems to police and punish gender-based violence. They questioned how systems that regularly did violence to women, to queer people, to trans folks, especially Black, Indigenous, and other people of color, could actually keep victims safe. So this is the kind of guiding theory, the theoretical underpinning for the work that I do now. And again, right, it's been a transition. So I took my first case involving an incarcerated survivor in 2013 when I came to the University of Maryland and started what was then called the Gender Violence Clinic. I had dabbled with criminalized survivor work a little bit before then. When I first came to Maryland, for example, I asked, are there incarcerated women who were subjected to intimate partner violence, and was told, no, no, no. All of those women got out in 1994 when Governor William Donald Schaefer did a mass clemency. And of course, nothing could have been further from the truth. I have yet to meet a survivor of, I have yet to meet an incarcerated woman who is not a survivor of some form of gender-based violence. But at the time I thought, okay, well, I'm here to teach a family law clinic. It's probably not within my remit anyway. It's just something that I've always been interested in. Several years later, I was doing a family law workshop in the prison, and women were saying, well, I'm here because of domestic violence. Domestic violence is why I'm here. And I thought, oh, okay, that seems inconsistent with what I've been told, but again, not really what we do. But when I started my new clinic here at Maryland, I had the opportunity to do pretty much anything I wanted. And so the Gender Violence Clinic was organized around the kind of people we served rather than the kind of substantive law that we practiced. And the people we served were people for whom gender and violence had touched each other in any way. And that really opened the door to being able to work with incarcerated people. We did in the early days a little bit of everything. I mean, everything from immigration to protective orders to family law to actually replevin, which I could not have even have told you at the time what replevin was. I only remembered from property that it was for a cow. And I'll happily tell you what it is if you've forgotten it as well. But little by little, I found that work with incarcerated survivors was what I was most passionate about, and decided, with the unbelievable help of Kate Cruz, who told me that she switched up the topic of her clinic every 3 to 5 years, and I had been teaching essentially the same stuff for like 13 or 14 at that time, that I could switch it up. And so started to take more and more and more of these cases. And then when the pandemic hit and we couldn't get into court to do the family law work, thought, well, this is the right time. And so since the pandemic, we have exclusively provided representation to criminalized survivors. And again, very loose definition, anyone who has experienced some form of violence or trauma that is related to gender and is incarcerated for it. And so because everyone has, we're able to do kind of a much broader swath of work. And then last year, changed the name of the clinic because students were still thinking that they were coming into a standard domestic violence clinic where they were going to do protective orders and family law. The clinic is now called the Gender, Prison, and Trauma Clinic, which I think better reflects the work that we do. So if you're wondering what abolition feminism looks like in practice, right? We always start from the kind of premise that, well, abolition is you burn it all down. And while I firmly believe in burning it all down, there are lots of things that we can do along the way to that. And also, I think it's really important as a teacher to recognize that not everybody stands in the place where I stand. And it took me 28 years to get here. And so you want to create places along the way for people to do the work and feel good about the work that they're doing. So in terms of policy, right, abolition is defunding the structures that are driving criminalization and dedicating that funding to the other kinds of things that ensure that people have all of the things that they need to live and thrive and survive. But those way stations are what critical resistance has called non-reformist reforms, things that shrink the criminal legal system, free people from cages, and diminish the state's capacity for violence. And so things like opposing laws that increase the reach of the carceral state, the big debate that I'm involved in now is whether criminalizing coercive control is a good idea or not. Repealing laws that are putting people in cages and keeping them there, things like mandatory arrest, which, by the way, mandatory arrest is passed starting in the late 70s through the early 80s, because there's this research that suggests that arrest deters intimate partner violence. One, that research has since not been replicated, was not able to be successfully replicated, but two, had the consequence of actually increasing the number of women brought into the system, not because women had all of a sudden become more violent, but because of the way that police were implementing those laws. And so mandatory arrest has been a significant driver of the criminalization of victims of intimate partner violence. Felony murder. We have a number of clients whose partners were engaged in crimes that they forced, coerced, or otherwise kind of had their partners involved in. And our clients have been convicted of felony murder. That's first-degree murder in Maryland. It carries a mandatory life sentence. And of course, mandatory sentencing that keeps people in. So those are big things that we, should be thinking about. How do we get rid of those laws? Then things like eliminating cash bail. Bail is significantly responsible for keeping women incarcerated and has a disproportionate impact on women, and obviously low-income women significantly, is much more significantly than anyone else. Other forms of work that we can do and actually do in our clinic, survivor defense work. So, one of the interesting things about this is that this is not just for lawyers, and there are real opportunities to teach students to work in collaboration with community around things like survivor defense. So defense campaigns are doing things like letter writing, financial support, visiting, fundraising to support the incarcerated person, social media outreach, court watching, pressuring prosecutors. And those relationships can be really fraught because communities may have a very different idea about what lawyers should be doing than lawyers have. And communities may not understand some of the ethical and other structural impediments to implementing some of the things that they really want to implement, or what the outcomes of some of those things can be. So there was, for example, a survivor defense campaign around a criminalized survivor where they were picketing outside of the courthouse, and the judge revoked the woman's bail in response to it. So there are these really important kind of questions about how lawyers can work with survivor defense campaigns to ensure that the narrative is consistent with what's being said in the legal case, that the system kind of understands what the parameters are. There's all kinds of stuff going on there. Clemency work is where we started in the gender violence clinic and now the gender prison and trauma clinic. And by clemency, I mean broadly parole, commutation, and pardon. So our first cases were parole cases, and that was a system that was totally new to me. I firmly believe, by the way, that every time I've had to start over in a new practice area, I've been at my best as a clinical teacher, because those are the times I've been able to say to my students with a straight face, I don't know what the answer is here. Let's figure it out. And so they don't feel like you're hiding the ball from them. They may feel a little insecure in that you don't know what you're doing any more than they do, but I try to make them know that, any good lawyer knows how to look things up, right? We don't know everything. We know how to figure stuff out. And that's what we do. So we started with parole, a system that I had no exposure to before, and now represent, I think we've had about 25 people released since we started doing this work, most of them through the parole system. My students meet with clients to create parole packets where they interview the clients to create life stories. They write legal memoranda around the parole consideration factors. They advocate for their clients with a parole commissioner. They prepare the clients for the parole hearings. So it's not in court advocacy, but it is really serious advocacy nonetheless. We are working on commutations for people who have been sentenced to life without the possibility of parole, because that is the only avenue that is available to folks. And I should say, this is not a place where the rest of the bar is clamoring to do work, because there's really not much money in it, if any. And so there's this lovely niche for students to come in and be able to do this work, especially around the folks who have life without, because really nobody is focused on them from the private bar. So it's a beautiful place for students to come in and do really meaningful work. We are, thinking about, what does it mean for a prison to be gender responsive or trauma informed? Let me just say, there's no such thing as a trauma informed prison. Prisons are trauma factories. So it's just a ludicrous idea that you could have that. And what gender responsive often means is offering stereotypically gendered programming in some way. And so you've seen, over the last several years, most notably, I think, in California and in New York, where there have been calls for new women's facilities, an equally strong backlash saying, yes, the facilities are inadequate and disgusting, but don't build another women's prison and don't lie to us about it being trauma informed. The last thing I'll say about kind of the non-reformist reforms that we can think about is that we need to invest in prevention, obviously, and offer alternatives, but really this idea of exceptionalism. So, and it's particularly an issue for those of us who come from the world of domestic violence, because for so long, we've had what we've called domestic violence exceptionalism, where it's like, oh yeah, you can, reform all of this, but don't do that in domestic violence. It's too dangerous. You can have bail reform, but don't have it for domestic violence. You can get rid of enhanced sentences, but don't do that for domestic violence. And that rests on a belief that domestic violence is more dangerous than any other form of crime, but also that all domestic violence looks the same, and that criminalization is doing anything to stop it, which I would argue it is not. Exceptionalism in the context of abolition works in somewhat the same way. So one of the things that's happened in the last several years is that we've seen legislation designed to take a second look at various constituencies within the criminal legal system, most notably juveniles. After the Supreme Court's decisions in Miller and Graham, states were forced to take a good hard look at whether they actually did have meaningful opportunities for parole for juveniles. And in some states, they created second look legislation that says, if you're sentenced to life in prison before the age of 18, we will take another look at you, because we recognize that the brain science says juveniles are different. There's been a similar move around intimate partner violence. And so something like the Domestic Violence Survivors Justice Act in New York, which is amazing in that it's allowing a certain group of people to get themselves back into court to say, the court did not sufficiently consider the impact that violence had on my case. And if the court had considered that, it would not have sentenced me in this way, or it should not sentence me in this way now. It's a wonderful tool for victims of violence, but what it starts to do is to essentially cream off of the top those more sympathetic populations, that leaves us with a group of people who all seem to belong in the criminal legal system. So Ruth Wilson Gilmore has said that, arguing that one group of people, for example, criminalized survivors, don't belong in the carceral system, quote, establishes as hard fact that some people should be in cages. And it does so by distinguishing degrees of innocence such that there are people inevitably who will become permanently not innocent, no matter what they say or do. And so there's this real tension in our work around, do we believe in abolition for everybody, or do we only believe in it for certain people? I believe in it for everybody, but I recognize that there are people who are just not in that place yet. And I don't want to say that laws like the Domestic Violence Survivors Justice Act aren't kind of, again, stepping stones on that road, though there is some controversy about that. If we had a DVSJA in Maryland, I would absolutely be using it to try to get people out of prison. And so I've kind of come to a pragmatic abolitionism that says we should be using any tool that we have to get people out. So as I said, in our clinic, we represent clients in parole, in sentence modification, in commutations, in presidential pardons. If anybody ever wants to see it, I actually have a presidential pardon on my phone. Presidential pardons are like a needle in an Everest-sized haystack. And it didn't happen. We did the legal work, but it really happened because our client had a close relationship with Senator John Cornyn, who had a close relationship with Donald Trump. So ironically enough, my presidential pardon for my client came from President Trump. And we're soon going to move into post-conviction because we've had some issues come up. And every time we move into a new area, I have to learn that area. I have to feel competent in doing it before we start to represent clients. We work on legislative reforms, and we provide support to community-based organizations, whether that's writing a white paper, doing research for them, that sort of thing. What these our cases, I should say, involve intimate partner violence, trafficking, rape, sexual assault, but they also involve questions about how do police and prosecutors and judges and executive decision makers exercise power? How does gender-based violence pervade these systems? It's not on my slide. I can't believe it's not on my slide. How are race and ability and heteronormativism and all the other things that we're talking about as intersectional phenomenon also affecting these conversations? Are our white clients having a different experience in the system than our clients of color? And of course, the answer is yes. So we're having all of this conversation. And then as we're having these conversations and we're working with these clients, the students are working through some really complicated thoughts about the criminal legal system, their role as lawyers, kind of how they see themselves belonging in this system. Some of my students come in and they want to be prosecutors. And it's a pretty big eye opener to walk into a prison for the first time and to have to grapple with this question of, could I put someone here? And I should say the Maryland Correctional Institution for Women, which is where we generally practice, as prisons go, isn't that bad. It looks like a rundown community college with razor wire around it. And that being said, I wouldn't want to be there for 5 minutes if I didn't have to be there. It's a terrible place. Prisons are terrible places. People are being caged. And if you're going to be a prosecutor in this system, you better know what that looks like and feel good about what you're doing. And so when I have students go on to become prosecutors, I know that at least they are thinking more thoughtfully about, or more critically about, who they believe should be caged, knowing that, and I'm very clear with them. I'm super transparent about my place in all this. And honestly, why wouldn't I be? Like, it takes you 2 seconds to Google me and know what I'm saying about this. So why would I ever pretend to hide the ball about it? But I also want to create a space for them where they can work their way through these questions and come to a different place than I come to in terms of their final answer. Some of my students come in wanting to be public defenders, and find either, some of them find that, yes, I definitely want to be a public defender. And I'm not a public defender. Like, the fact that after 30 years of being a lawyer, I now am a criminal defense lawyer, which was not anything that I ever thought I would be, is kind of hysterically funny and also interesting to me. And I'm really open about that with my students to say, look, this isn't how I started, and life is long and it takes you a lot of places you don't necessarily think you're going to end up. But this is how I got here. And I'm really transparent about that with them, that I'm not neutral about where I stand on these issues, but that there is space to feel differently. And I'm really clear about where I came from. And the reason I started this talk where I did is because I think that story is really important. We are so quick as a society to judge people for changing their minds and for growing and changing over time. And so I really want to normalize saying, I was here and now I am 180 degrees from here, and that's okay. And here's how it happened. And here's what that learning process looks like. And if you're still here, that's okay too. But be open to the kind of learning and conversation that might get you to a different place, or just let you really feel good about the beliefs that you do have. What I found over the last several years is that teaching abolition in law school is actually getting easier and easier, because so many of our students are coming into law school with a different orientation. And I don't know if this is true for other people, but it's not as though these ideas weren't in the ether for quite a long time. And those of us who think of ourselves as progressive, these ideas were around, but there was something that happened in 2020, particularly around the murder of George Floyd and then around the murder of Breonna Taylor, where I think people just started to look at these issues differently. And so I find that our students are coming in a very different place. They are open to abolition. They want to understand, what could the role of lawyers be in all of this? And, Mariame Kaba has said, and I think she's right, not in my lifetime, right? I won't see abolition in my lifetime. And so there will still be people in cages. And as long as there are people in cages, there is work for me to do to try to help them not be there anymore. And that's kind of part of the lesson also that we're trying to impart to students, is that you can be part of this change, this absolutely imperative and kind of society defining change that is coming. I steal from Miriam a lot. And so the other thing that I've been thinking about a lot lately, given everything that's going on in the world, is that the idea that we all have something that we can contribute, a role that we can play, and nobody is expected to be able to do everything. So I was prepping, we had a big hearing yesterday, and I'll talk about that in just a second, but I have been up to my ears in prepping for this hearing. So I didn't go to the March on Washington. I might have otherwise. I didn't do other things because I kept thinking to myself, I know that there are all these things in the world that I feel strongly about and I want to pay attention to, but I feel like this is my lane. Like this is the place where I can help to make society a little better and a little more just. Maybe that's rationalization, but I don't think it is. I think it's recognizing that not any one of us is going to do all of the things, but that we can teach students to do these things. We can be focused on them, and that can be our role. And our students are there for it. They're excited to talk about these issues, even if they're not 100% there yet. So this is what it looks like when a criminalized survivor is released from prison after serving 31 years of a life sentence for felony murder. Rudera Bailey's crime was being forced to clean up after her abusive partner committed a murder in her apartment. Ms. Bailey went to the police as soon as he was arrested. She showed them where the murder weapon was, and she cooperated fully. But 5 months later, she was charged with the murder that he committed. Ms. Bailey is a client of our clinic. She comes in to talk with our students at the beginning of the semester. And what she tells them is how important the work that they're doing is, that she felt, and many of our clients say that they feel forgotten. Once they're convicted, they feel like nobody cares about them, that they've disappeared into these prisons. And what our students are able to do is to make them know that somebody sees them, that they're not forgotten, and that somebody is fighting for them. We lose a lot more than we win, a lot more than we win. Everybody who does criminal defense knows that. I'm just starting to learn it. But I've also challenged my students to redefine what they mean by winning. So for me, winning is, it's great to get a good outcome in a case. We did a case yesterday, as I said, a hearing for a modification of a life sentence for a criminalized survivor who's, I'm shortcutting it, but her crime really was to tell her family that she had gotten beaten up, and somebody else in her family decided that it was incumbent upon them to take care of it, which led to her boyfriend's murder. And she was convicted of first-degree murder as a result of what the prosecutor said was a conspiracy. And she's done 21 years of a life sentence. And yesterday, her sentence was suspended to all but 40 years. 40 years is still a ridiculously long amount of time. But she knows that she's going home. You know, yesterday she woke up and she wasn't going home. And last night when she went to sleep, she knows she's going home. And that's amazing. And that when you are able to be part of a student learning to get a result like that, it's phenomenal. But mostly that's not what happens. And so we think about winning as, does the client understand what's happening to them? Does the client feel heard? Was the client a partner in this representation? Does the client feel like they've been able to put that story into the system in a way that they feel good about? And if we're able to do those things for our criminalized survivor clients, that is a form of fighting against the state as well. That the state railroads people, it treats people inhumanly. I'm so surprised to be this person now, but knowing that anything that we do to help our clients feel heard and validated and humane in the system, it is a huge benefit. So while this is the goal, and it's a wonderful goal, we had, you know, all of our students were there with signs to welcome Ms. Bailey home. It's not our reality most of the time. But the more that we do this work, and the more that we help students kind of grapple with these ideas, the closer that we get, I think, to this for all of the people that we want it for. So that's where I'll stop. And I hope that if people have questions, please feel free to raise them. I'm going to open the chat now. So I see Rebecca's question. Okay, so how do you incorporate education into the parole and clemency petitions? It's very case specific. And Rebecca, as you know well, one of the real challenges in doing this work is that we are in many ways hemmed in by the facts as they were proven at the time of conviction. So because we are post-conviction, the facts are set. And if we decide that we want to push against those facts, we better have really good backup for it. And real conversations with clients about what it means to push against those facts. Because for us, the first thing the Parole Commission is going to say is, well, you don't take responsibility. So one of the things that we talk about a lot with the Parole Commission and with my students is the difference between an explanation and an excuse. That the history of victimization creates a context for the deciding body to understand how this crime took place, and that it's not being offered as an excuse for whatever it was. It's being offered as an explanation so that the governing body has a better understanding of everything that went into it. We sometimes use some of the data that's out there, most of which is now compiled in my book as kind of a handy reference about kind of the prevalence of felony murder convictions among people who've been subjected to abuse, and the prevalence of coercion and duress among people who've been subjected to abuse, so that there's good social science literature out there, and we will incorporate that into our clemency petitions as well. We'll footnote it and we'll kind of draw those connections in that way. But it's a very fraught question, because I absolutely have had parole commissioners say, well, you're not the victim. You're the person you killed is the victim. You're not the victim. And if you think you're the victim, then you're not accepting responsibility. And so it is a tightrope that we walk, and it's a hard one. So I don't know if other people have questions, or if you just want to unmute if you have questions, or you want to tell me that's all ridiculous. That's fine too.
So you're getting a question in the chat just about access to syllabus and readings, and then Jill, please.
Yeah. So
a question as well.
I'll say, Elizabeth, I don't assign too much substantive reading on this issue, because I spend a lot. So we focus in our seminar primarily on skills. I'm teaching them this. So I assign the first day of class, I assign them the first chapter of my book, because really, why bother to write it if you can't assign it? But I don't make them buy it. So that's how I deal with my own guilt about that. I assign the first chapter so that they have the context for what the clinic is. And then in the week that we do case theory, I give them the chapter that is on parole and clemency and commutation, so that they understand what the fora look like that we're operating within, and have a better sense of kind of how our storytelling translates in these particular settings. But I don't give them much substantive reading outside of that, because it just feels like too much. It's like one more thing that I'm asking them to do, and it feels like too much. I teach a little bit of I teach intersectionality on a regular basis through rounds and through our team meetings, but I don't do that in seminar as kind of, this is a separate subject. We do talk about cross-cultural lawyering, and I use Sue Bryant and Jean Peters' work mostly on cross-cultural lawyering still, again, because I'm a dinosaur, to do that piece of the work. And then we're having those conversations all the time. I've just found over time, they're going to skip the reading. Seminar feels to them like the least important thing. So I've got to find, if I really care about this, I find other places to do it. And what happens in rounds is that we are having these conversations all the time, because they are seeing this come up in their cases. Just every time they go into the prison, they're getting something that they're bringing back and saying, what the hell? Like, how is this allowed to happen? And then we're having the conversation about how it's allowed to happen. But I'm happy to give anybody my syllabus. It's not terribly helpful, I think, because it really is just, this week we're doing cross and this week we're doing openings. But I'll share anything that I have with people. My friend Jill, you got a question?
Hi, Leigh. You just covered what was my first question, which was how do you teach intersectionality in this context and with the students? And I really love the way you framed it. Actually, in the beginning of your talk today, you gave several concrete examples, right, of how intersectional marginalization has played out. So my other question relates to vicarious trauma, one of our all-time favorite topics, right?
Yeah.
And how you navigate with students when their own traumas are showing up,
Yeah.
and how their own kind of experiences, just as human beings and as law students, have either consciously or unconsciously indoctrinated them into this paradigm, the carceral paradigm.
Yeah. So the one thing that I do teach substantively is trauma. And it is a lecture from slides that I stole from my friend Jess Emerson, who used to teach at UB and now runs, I don't think she's teaching exactly at UB, but she's running a trafficking survivors clinic for a pro bono organization at UB. And I have all Jess's trauma stuff, and I just lecture that, because they don't even have oftentimes the vocabulary to understand what it is that they're experiencing. So I want them to have a vocabulary of trauma that they can use so that they can recognize it in their clients, but also recognize it in themselves. Part of that lecture is about vicarious trauma. And there's actually I wish it's on my shelf, but I'll get it for people who want it. A British Bar Association put out a great book about trauma and lawyering that one of my students brought to me, and it's fantastic and has a lot of really good stuff about vicarious trauma, some of which I've worked into that lecture. So that's the first time I name it for them. And we talk about, okay, so what will it feel like if you're experiencing this? And, you don't have to tell me what it is you're bringing to it, but are you bringing to it things that you think could be triggering for you? And how are you going to know when that's happening? And what are you going to do when that happens? We talk about self-care incessantly. And not in the sense of like, go have a spa day, but like, are you checking in with yourself? Are you eating right? Are you exercising? Are you doing the things that you need to do to function? And one of my colleagues suggested this a couple of years ago, and I've started to do it. I actually have them log their self-care hours on their timesheet as part of their time, and say to them, I want to see that you're doing this kind of self-care. This matters. This is important for your life as a lawyer. You've got to be able to do this. And then it's just a complete door open policy all the time. I mean, like, I know this has happened with you and it happens with me, right? When somebody comes in, it's not the first time somebody's cried in my office, this semester. Is probably not the first time today. And so kind of just making sure that I am an open door for them and a safe space for them to come in and have these conversations on a regular basis. But the biggest thing I found is that, we get in our clinics, survivors, because that's why they came to law school. And one of the things I normalize for them is to say, you don't have to do this as your job. You may find in this 3-month period of time that this is too much, that, yeah, this is why you came to law school, but you can't do this all day, every day. And that's okay. That's what clinic is for. You figure out kind of, do you love it? Or is this just a part of my experience that it's just too much for me every day? And just having that conversation with people has been so amazing, where they feel like, oh, I don't have to carry this burden all day, every day. This doesn't have to be what I'm immersed in all the time. And that's okay. So I think that's a big part of it too, is kind of saying to them, if you are experiencing this, know that this is kind of going to be a feature of your life. Is this something that you want? And if it's not, don't do it. And that's okay. Like, there are other people who will do it. Go do, somebody was like, I really found that I loved workers' comp. I was like, workers' comp is public interest law. That is helping low-income workers get what they need to survive. Go do it. Don't do this all day, every day.
We have a couple minutes left if there are any other burning questions for Leigh.
Hi, Leigh. Carlotta from the Women's Prison Project. How are you?
Hey, Carlotta. Good. How are you?
Good. I'm just curious to hear about what you all are planning for post-conviction work. It's really exciting that you're moving into that. that realm. And, we do that, and it's a lot of work. And so I'd just like to hear about what you're planning.
So the way that we ended up edging into it is because in Maryland, the failure to file for so we have a rule that allows you to file for a motion of modification of sentence within 90 days of your sentencing. And that's also true within 90 days of any resentencing. And the failure to file that motion for modification is per se ineffective assistance of counsel. So on this very small issue where there is discrete and very good law, we are starting to file on behalf of clients who did not get their appropriate modification. And we are unbelievably lucky in that in the cases that we have, the defense attorneys who have failed to do it have said, absolutely, it was my fault. I will not, I'll fall on my sword for this one because it's my fault. And so that's the starting place. I see that my friend Erica Suter is on this thing, and I will say that I have enormous respect for the lawyers in Maryland who do post-conviction, because I think it is super complicated, and I have no desire or intention of going into the complexities of it without teaching myself and learning first. So I have actually regularly asked, and I just never have the time to do it, our Office of the Public Defender, like, can I come intern for you for the summer in the post-conviction unit so that I can learn this stuff so that I can do it? So that's the very small step that we're taking. Our Office of the Public Defender post-conviction unit, to the extent that it's not their lawyers who have done this, has been incredibly helpful in kind of giving us some guidance, and I'm doing it very slowly and carefully. I really do love getting into new areas, but this one I'm super, super cautious about. And I should say, in kind of one of the biggest cases that I've ever been involved in, it was Erica who was doing the kind of hardcore post-conviction lawyering so that our client could benefit from it, because we were looking at it and going, I don't know, like, I don't, and it was a super complicated argument. It was only because of Erica that we were able to make it. So clinic collaboration, good colleagues in the community, draw on the people who know the stuff that you don't know.
It sounds great. I'm just excited that other people are going to be doing it, and more of it needs to be done, obviously.
Yeah, I don't have a clue. I will say the last thing, just before we log off, I have been collecting or trying to collect who's doing work with criminalized survivors in the post-sentencing environment, because I am hopeful that someday, and my friend Kate Mogilescu at Brooklyn and I have had this conversation repeatedly, I'd love to put together a conference for those of us who do this work to come together and talk about it, and to have to start building those relationships out. So if you are doing this work in your clinic, will you just drop me an email and let me know so I can add you to the list, so that as we start to think about putting this thing together, we have a good sense of what the community looks like. So, and thank you guys for having me.
I mean, and such a wonderful note to end on too, right? Kind of continuing the strength and power of the clinical community, even in its kind of smaller constituencies. Thank you so much, Leigh. I know, for me personally, who has a tendency to get really excited in July about a new area of law, and then November comes around and I'm wondering what in the world I've gotten myself into. It is affirming and refreshing and inspiring to hear about your work in this space and all that you continue to do on behalf of your clients and your students. So thank you so much for sharing with us today. Thank you all for joining us, and we hope that you have a wonderful end to your winter terms or fall terms, and look forward to seeing you for our series as it continues in the 2024 school year. Best wishes, everyone. Thanks again for joining us, and thank you, Leigh.
Thanks all.